Human beings have the right to die with dignity. Landmark judgment of the Supreme Court making passive euthanasia legal in India. The top court has also validated living will, which allows a patient to choose medical treatment to be administered when he or she is terminally ill.
The right to life is inclusive of the right to die with dignity. That is something which was unacknowledged, or rather perhaps not very clearly interpreted in law thus far, and that has changed, and that is why this ruling is so significant.
While passive euthanasia has been granted by the Supreme Court, it has laid guidelines and framework to allow mercy killing.
सुप्रीम कोर्ट ने साफ-साफ बोला है कि हर नागरिक को ये इस तरह का फैसला लेने का पूरा अधिकार है.
Very progressive, very pragmatic judgment, extremely welcome. There is always a word of caution when such path-making judgments are written, that it should not be open to misuse.
The Supreme Court's decision comes as a big relief for several people who've been waiting for this verdict. Anamika Mishra was seeking euthanasia for her daughter who is terminally ill. Mirror Now salutes the top court for the landmark judgment. Mirror Now report.
You're watching the Urban Debate on Mirror Now. Thank you for staying with us. This is an important judgment, and the reason why we need to talk about it is because when the Supreme Court makes decisions like this, it should be primetime news and it should be something we understand. The visuals you're looking at on your screen right now were of a nurse in the KEM hospital in Mumbai who suffered through a terrible rape and attempt to murder, in which a ward boy assaulted her sexually a few days before her wedding day, used a dog chain and left her there with the dog chain around her neck, cutting off the oxygen supply to her brain for several hours. As a result, she was left in a coma or a vegetative state for over 40 years, where the other nurses at KEM, generations of them, looked after her. It also sparked the conversation of whether or not individuals or family members should be allowed the decision to withdraw care and let the person go with dignity. That was the decision that the Supreme Court took today, when it decided that the right to a death with dignity comes hand in hand with your right to life, which is a fundamental right in this country. We want to be able to understand what this means. And we also heard Pinky Anand tell us, Geeta Luthra tell us that it's also, the Supreme Court made sure that there will be no misuse. So we want to understand how the Supreme Court made sure that there will be no misuse. Let's understand what passive euthanasia really means and what new right does it give us as citizens of this country. You can also call in and give us your views if you want to. Joining me in the studio, Dr. Sanjay Nagral, surgeon and chairperson of the Forum for Medical Ethics. Pinky Virani is the author and journalist who had appealed to the Supreme Court to let Aruna Shangbag, the nurse in question, die. Aditi Saxena, advocate for Human Rights Law Network. Sumansi Raman, political commentator. Geeta Luthra, senior advocate with the Supreme Court. And Amitabh Sinha, lawyer and leader with the BJP, joins us right now. I welcome all of you to this conversation. Dr. Sanjay Nagral, I'm going to come to you first. You've known Aruna Shanbag in KEM Hospital for many years, and this is, as you said, a complicated but a really important judgment. Can you tell us, technically in medical terms, what does this mean for a family who's caring for someone, or for someone who wants to make this decision for themselves?
Right. So, yeah, as you said, I was a medical student and I'm the staff of Mumbai's KEM Hospital for many years, and I have been witness to the cries of Aruna Shanbag, who was lying in the side room of one of the medical wards there for many years. Essentially, there is a lot of terminology that is important to understand when one talks about the whole issue of end-of-life care. I think that's the broadest term. So you have the act of euthanasia, which usually implies a very active way of terminating life, which is something which this judgment clearly has said should not be allowed, because that actually means that you effectively, it's called physician-assisted suicide. But on the other hand, you have a more passive variant of that, which is you withdraw care. So you don't do things beyond the point. You stop medication, you stop drugs, you perhaps even reduce the artificial support that the patient is being provided, and that's passive as opposed to active. So that's withdrawal of care. And I think essentially what the court has said in this judgment is, number one, it has said that you as an individual in your life can choose to clearly state in a sort of a living will or advance directive that if you are unfortunately in that situation, you should not be subject to unnecessary life prolonging treatment. So that's part one. And part two, the judgment kind of alludes to the fact that they recognize the fact that India also needs to recognize the idea of passive euthanasia. And they sort of suggest ways to do it.
Because up until now, we didn't have the ability to tell our family members that if something happened to me, let me go.
So you could have said this to your family members, but what was happening up to now is that it was all hush-hush. The medical fraternity was extremely confused on this issue. The healthcare establishment was completely confused at see how to deal with somebody's wishes. And I must say this, that even now, even after this judgment, if you ask me, my concern would be that is the healthcare system in India ready to handle the complexities that will arise out of this.
Yes.
So for example, a very simple thing is what is a terminal illness? What is a withdrawal of care? So we'll have to now actually start the process of defining these terms.
Absolutely. I understand Sumansi Raman has a different opinion on this. Sumansi Raman, do you believe this is not a good idea? Are you in support of the Supreme Court's decision?
Faye, I think you have to look at two things. One is in an ideal society where checks and balances are in place, where the rule of law can be established quickly and the guilty can be punished in a reasonable span of time. I think that in principle this would make sense. In India, I'm really worried. I worked as a critical care physician for many years, and I've seen the situation day after day after day. And I think that you have to consider two things. One, this passive euthanasia is de facto already existing in India. You see a large number of patients and their family members who actually come to you and tell you, don't intubate this patient, don't put the patient on a ventilator, keep the patient pain-free, do a little, do whatever is necessary until it comes to a point where you have to put them on systems. And this happens every day in ICUs across India. So de facto, when you can sustain life by putting a patient, intubating a patient, putting a patient on a ventilator, adding drugs to keep the BP up, and you're not doing that, technically that is passive euthanasia already. So de facto passive euthanasia is already happening across the country. This is something that we have to first understand. The second part is the worry that is really there is that what we are now actually, in practice how it happens is the family tells the physicians, the hospital alone to safeguard itself has forms. You have what are called DNR forms, or do not resuscitate forms, which the patient's family can sign and say that, should there be a cardiac arrest beyond a point, I do not want resuscitation actively done. So all of this is already available in the system. The risk that this judgment actually exposes us to is if there is a, let's say hypothetically, there is a living will which somebody actually wants to recant. You can't, how do you actually, establish or give them the opportunity to do that if they are not in a position to do so, if they are unconscious and so on. Second, you're taking decisions away potentially and putting it in the hands of family members who may be having motives for dealing with the decision in the way they decide. They could have, for instance, they may want to cut the cost of care on a relative. They may be interested in taking the property. So there are so many things which are of serious concern, and I am honestly afraid that this judgment will cause a huge amount of potentially could be misused in a very big way in India.
Let me bring in Geeta Luthra. Geeta Luthra, thank you for joining us, Ms. Luthra. Tell us, what do you believe are the checks and balances here to prevent misuse? How can misuse be prevented when it comes to this particular judgment or order from the Supreme Court?
See, I don't think you can ever prevent misuse. You can perhaps reduce it. One of the aspects I think the court has looked into, I haven't looked at their judgment in detail, but I think one of the aspects the court has looked into is having a medical board. You know, in Aruna Shaubag's case, they had a medical board, and so one of the aspects would be, is the person in a vegetative state? Is the physician certifying he's in a vegetative state? Is there a living will which says that this, if I am in a vegetative state, then I don't want this continued? Now, having said all that, the question is the scope of misuse, however many checks and balances you have, is likely to be there, because you will be dependent, one, on the family, two, on medical care, three, on a genuine living will, and you don't know whether there's a genuine living will or a forged will. So there are 3-4 parameters which will have to be looked into. The court has basically laid down the legal principle that it is permissible. Now the parameters will have to be laid down, I think, in detail by the medical council in a manner that there is the scope of misuse. And you can never, whenever there is legislation, wherever there is law, there is a possibility of misuse. We have to just do the checks and balances so that the misuse is reduced. Now, one of the aspects the doctor just said, who was in critical care, that every day they are practicing passive euthanasia. Every day people will come, my patient has been on a ventilator for 20 days, no purpose, it's irreversible, remove the ventilator. What happens? It's really a case, in a sense, of passive euthanasia without an active will. But there is to be a time where a doctor calls it a day, or calls the patient's family and says, look, I can't do anything more. Your patient's not going to improve. Now you tell me what are your instructions, and the patient's family will say, okay, let's wait for a few days, or they'll say, let's call it a day and let's keep it pain-free. So this is happening. Question of misuse, I think misuse possibility is something which you can't wipe away. And I think it's only for the doctors, and there are doctors and doctors. You know, you have all kinds of people in the profession, as in all professions. So that's the fear, I think.
I also want to bring in Pinky Virani at this point, author and journalist.
One quick point, Faye.
Yes, Suman. Yes, Suman.
One very quick point. Yeah, one very quick point, Faye. See, basically, if you want to find out the statistics in terms of how much of passive euthanasia is already going on in India, it's an easy way of doing it. You just need to identify the number of patients who are discharged against medical advice from hospitals and subsequently match it with a death certificate within the next day or two. Most of the time what happens when the hospital is told to take the patient off the ventilator, the hospital doesn't want to take the call. So it will say, look, we can do that for you, and that this will be told verbally, but you have to sign an against medical advice that you're taking the patient away from the hospital on your own free will. The hospital will then organize the ambulance and so on, and then shift the patient back to the home, and the patient usually may succumb within a few hours or a day or so. So if you take the number of patients who got against medical advice certificates, map it with those who died within 24 to 48 hours, you'll get a good idea of the extent of passive euthanasia already going on in India.
All right. I just want to bring in Pinky Virani, because I will come back to Dr. Nagral to understand if this will in any way put the medical fraternity at ease, which I don't think he believes it will. But Pinky Virani is an author and a journalist. She wrote the book Aruna's Story, which is what publicized Aruna's story that much. But she also appealed to the Supreme Court to let Aruna Shanbhag die. She was interestingly opposed by the nurses who were looking after Aruna and the management of KEM Hospital. But Pinky Virani, you said that this is Aruna's gift to India, the judgment that has come today. Do you believe it will not be misused?
Good evening, and Good evening, and thank you for inviting me on your show. When I approached the Supreme Court in 2009, in fact, the Supreme Court gave its verdict on passive euthanasia in 2011. That was a 2-judge bench. What we have today is a 5-judge bench revalidating and re-endorsing that particular judgment of 2011. So I'm extremely grateful to the Supreme Court of India doing that. What they have added today is the living will. And I have just very quickly looked at the Supreme Court, today's Supreme Court judgment, which has been uplinked on the website. 500 plus pages. It's going to take me time to read it. But these issues that are coming up on living will, specifically related to passive euthanasia, the Honorable 5 judges have listed it in very great detail. So irrespective of whether you believe in passive euthanasia, whether you believe in the living will, I would urge all legal students, all doctors, everyone to just read what is a fine piece of judgment, even if it's 500 plus pages. Now to address the issue about whether you need a living will for passive euthanasia. If you read the 2011 judgment, you will find that the living will is in fact not required. The moment death sets in, there really isn't that much more to do. So all that has to be done by the medical fraternity and by the family, because they will need to work together. There is no question of one saying the family will be useless or the family saying the doctors will be useless. When do we need a doctor the most? When we are in complete and utter distress. When does a patient who is in fact on their deathbed need the family the most? When they are in distress. So the point is that everybody has to work together to see whether the patient is applicable for passive euthanasia or not. The 2011 judgment is very clear on patients who would qualify for it. And today's judgment spells it out even further. As far as misuse is concerned, alas, everything we look for loopholes.
Yes.
In this case too, we are likely to look for loopholes. But I doubt very much whether there can be too many in terms of when persistent vegetative state has set in. For example, you know, and you want to leave a living will saying, look, if something happens to me like Aruna, the only thing you're going to have to decide is whether you want it to be like her for 40 years or 40 months or 40 days or even in my case 40 hours. You know, I don't think I would want to be ever in Aruna's shoes, not even for 40 hours.
All right,
But it's not a call I can take now. It's not a call. There is not going to be a single case that's going to be applicable for all.
Okay, I'm bringing Amitabh Sinha in here. He's a lawyer and a BJP leader. Amitabh Sinha, and I just want you to react to some of the responses I'm getting from my viewers.
You were saying something.
Yes, from my viewers, they're saying, you know, how will we put the doctors under the scanner here? How will we make sure that the doctors are not being bribed or from, you know, members of the family to sort of get rid of elderly members of the family? This is a difficult, it has to, you know, judgment. It has to be carefully observed. So, Amitabh Sinha, this is a tough, although welcome judgment. This will be tough to implement and tough to make sure that nobody misuses.
Thank you for giving me a chance to speak. This landmark historic judgment is worth welcoming. You know, Indian judiciary has given its you know, impression about themselves that now they have changed from bookish people or bookish system to a system which is really human and really you know, concerned about the well-being of general you know, citizen of the country. Now why I am saying so, see, in every system or in every arrangement there are you know, apprehensions and loopholes. But the people who are criticizing this landmark judgment is basically those category of people who just criticize everything for the sake of criticism. Let me tell you why. See, this judgment has defined how a person should be given life with dignity. Life with dignity means living with dignity, and simultaneously, togetherly, it should be living, I mean dying with dignity also. So if a person in his lifetime also, if he thinks that his life with dignity means that dignity should be continued till his death, he should give a living will. In living will, he can just give his mindset that I should not be kept under any type of ventilator or such type of thing, because he or she wants that he or she should live with dignity and die with dignity.
Right.
Number one. Number two, the people are apprehending that doctors will be bribed and all. So the system must have positive approach and positive viewpoint towards every section of the society. Doctors, medical profession is a noble profession.
Yes.
We must have faith in medical profession and on doctors, and every passive euthanasia requires the consent and the positive advice from the board of physicians or medical board. And the prelude was getting started right from few months back, when the same Chief Justice bench had given permission to terminate the pregnancy in the advanced stage, when it was settled that the child is not in a position to live the life with dignity. So from that point, this prelude of this judgment was being prepared, and 3 cases were there. Then the entire decision was put before the medical board, and medical board then gave the type of certification. Then the mothers were allowed to terminate the pregnancy. So here also,
I just want to bring in Dr. Sanjay Nagral one more time. Dr. Nagral, unfortunately, there does seem to be a general sort of mistrust towards the medical community, even from the messages that we are getting on Inball that I just read out. Obviously, this is not, it's not a great place to be right now where we are, but this is something that needs to be addressed. The people mistrust doctors. They think that doctors could be bribed to go back on their oaths.
Yeah, so I mean, I'm not one of those who has a false sense of loyalty to my profession, and I think there is some basis why people are increasingly mistrusting doctors. But I just want to quickly respond to 2 or 3 things. Number one, the fact that, as somebody rightly said, a lot of patients take discharge against medical advice. It's a very sad way of doing it. That's not the way we should be implementing the whole issue of withdrawal of care.
Yes.
So that's point number one. In response to Pinky Virani, so the persistent vegetative state is a very distinct state to define and identify. But the problem I see is when you talk of terminal illnesses in general, how do you define it? And my concern is that it's not so much misuse, but how are we going to deal with the issue of the cost factor? If somebody is running up huge bills, and it could be something which is treatable, potentially treatable, needs dialysis, but there's no money for dialysis, and the family says we want to pull the plug because we cannot carry on the cost. So because we are not in a universal healthcare scenario. So we are implementing a strategy which is actually in many countries with this universal health care. And in a country which is on one side the rich are over-treated, the poor are under-treated, that kind of chaos,
but
we are implementing a very advanced strategy. That's my concern.
So actually, I know that I have one more guest who hasn't spoken yet, Aditi Saxena. Aditi Saxena of the Human Rights Law Network. Aditi, here's the question. Now, when the doctors say that there's no hope at all, and this person is terminally ill is one thing, but the example that Dr. Nagral gave us, where he said that we can't afford the treatment, that's a grey ethical area, Aditi. Where do you stand on that question?
First of all, I think we should take a moment to applaud this judgment for 2 reasons. One, it has stepped up to say that not only a person has the right to life with dignity, but also right to die with dignity, which is, in my opinion, far too late to have come to this country. Had it come much earlier, which it could have been, and Supreme Court had many instances to bring such a judgment, we would not have seen in the case of Ms. Aruna Shanbag that we saw. Second, I would also applaud this judgment that it goes ahead and says that it is not, we do not have to wait for any legislation to come in place and only then passive euthanasia can be allowed. This judgment exists, this judgment is there, lays down procedure, lays down all the contentions that could be there and in much detail while allowing passive euthanasia. Now, as to the cost, I agree with my fellow panelist that cost is a factor when it comes to a family making a decision to pull the plug or to not pull the plug. However, we should not forget that this judgment comes as a last resort to 3 conditions that it lays down, which is a patient is terminally ill, it is undergoing prolonged treatment where there is not much hope or no hope on the contrary left. And this treatment or this terminally ill that the patient is incurable.
Right.
Now, in a scenario like this, Supreme Court has time and again come out and said, Supreme Court has time and again come out and said that right to life is not merely animalistic existence. Now, what this condition lays down, or what how it spells out the condition of the patient is worse. It is in a vegetative condition.
Yes. Okay, let me just 1 second. I have someone on the phone line. I have someone on the phone line. Usha Rao is on the phone line from Bangalore, and she'll have questions that our panelists can answer. Usha Rao, go ahead. Sumansi Raman, I'm coming to you immediately after this. Usha Rao, go ahead.
Good evening. Yeah, good evening.
Good evening.
You know, it's a historic verdict by the Supreme Court. Just as we yearn for life with dignity, death too has to be with dignity, I think.
Yes.
You know, to prolong life endlessly when there is no hope of recovery is an agony both for the person who is undergoing the trauma and also for his or her near and dear ones. I think the only fear is that it could be misused. So my question is, what are the safeguards provided against its misuse? This is a moot question, you know. If a terminally
Yes, absolutely. Usha, I think that's the question our panelists were answering, where they said that there are 3 steps and it's not just a snap decision that can be made. Sumansi Raman had a rebut. Sumansi Raman, go ahead, please.
Faye, I'm concerned about 2 very, very important aspects.
Yes.
One is this question of, a patient who is in quote-unquote a vegetative state / terminally ill and so on. Now, in some cases, it is possible to define that. In many cases, it is very difficult to define that, and the definition of that itself depends in what kind of a healthcare setting you are. Second, from experience, I can tell you, the vast majority of decisions that are made on the financial grounds, on the grounds that the family has already pledged the property, they've gone deep into debt, and they simply cannot afford to keep the patient, sustain him at that cost anymore. So I think that we need to, and the third, very, very important, is there going to be, I haven't read the judgment, I don't know if it's there fully, is there going to be an explicit ban on organ donation in cases of passive euthanasia? If you're going to actually allow organ donation in cases of euthanasia, you are going to see a massive number of people who are going to have the plug pulled on them in collusion. I'm sorry, I mean, I agree with the doctor on the panel who said that we cannot, blindly defend our own fraternity. There are definitely cause for concern where you could potentially have people having organs sold in the, because after euthanasia. So I think that we need to address these concerns. There needs to be an explicit ban on organ donation in cases of passive euthanasia.
In fact, Sumansi Raman, I believe that one of the arguments,
and leaving it to a medical board. A medical board is basically, instead of 1 doctor, you're having 3 doctors. I mean, that marginally increases the safety, but it certainly is no guarantee.
Anyone who wants to answer this, because I do believe that one of the arguments for, passive euthanasia was organ donation, that you'd have viable organs.
Yeah, so I think Sumant, let me say this, that let's not confuse issues, because organ donation is brain death, and brain death is very, very explicit and definable. Yes, but the judges have used that to say.
No, I'm sorry. Now you're actually saying you can induce brain death now.
No, I don't believe that.
Let me just say that the judges have used that to say that even in the context of brain death, if somebody can have an advance directive to donate organs. Why can't they do it otherwise? In fact, that's what
yes.
the
Geeta Luthra also had a point to add to this. Geeta Luthra, go ahead, please.
So this argument of the court I don't find very acceptable. You know, one is organ donation, and you have a law for that, and you have a right for that. I don't think it should be mixed up as a ground to say passive euthanasia has to stand on its own feet, because it is your right to die with dignity. Now, the only question is, of course, I mean, people are traveling all over. Those who can afford would go to the Schengen countries. They would go to Switzerland. They can practice active euthanasia, leave alone passive euthanasia. The question is, can we ensure that we will not misuse it? It's extremely welcome, this judgment. And there's no reason why we shouldn't have it, because like all of law, which can be open to misuse, this can also be. But because it has serious repercussions with regard to property matters, old elderly parents, parents who are now dead weight, people, wives that you may not want, other family members or relatives that you want to get rid of, and you have lots of family members combine against one person who they becomes a person who is a dead weight. Those are cases where you have to be careful, and the state has to take the care
We now have a legal
that
way
it
of
is
bumping
not
them off.
a law which is being misused.
Right. We have Ram Mahmood.
So it shouldn't be a legal way.
Yes, it shouldn't be a legal way of getting rid of a family member. Ramamurthy on the phone line from Pune. Mr. Ramamurthy, go ahead.
Yep, it's a very historic judgment actually, and you know, so many. I mean, hats off to the Supreme Court verdict. So many patients, it's a big relief for so many patients who I mean, rather than suffering, this is a very historic judgment. At the same time, there are chances of misuse also. So in such cases, no, it should be not only the doctor should certify, also a local magistrate also should be present in turn. So the patient is dying, patient is taking this option with his own will.
No, but while that's a good suggestion, and you know, we can ask the legal voices on the panel to answer this. If we involve the local magistrate, is this likely to draw out longer? Perhaps, you know, since the whole point is to not prolong the pain or the you know, or the agony, will we wind up prolonging the pain and agony if we get the legal fraternity involved? Mr. Amitabh Sinha?
No. I totally disagree with such type of advices, because it will unnecessarily create bureaucratic hassles. See, we must, you know, have faith in the system. When we don't have faith in the system, we will find problems everywhere. And it was rightly discussed earlier by one of our senior panelists that if the misuse is being apprehended, so every system, every arrangement can be misused. Even IPC provisions of, you know, any prevention of crime, etc., that they can be misused. The police can be misused, the judiciary can be misused, the political system can be misused. So we are here to analyze this historic landmark judgment. This judgment is, you know, really a human angle. It has a human angle, and people can create and raise objections. But according to my perception, see, this is a very, very caring judgment about the humanity by the Honorable Supreme Court. Why? Because, you know, right to die with dignity was being discussed, and the demand was there since several years. But the bookish legal system was not allowing this type of thing. So just you know, this constitution bed headed by the Chief Justice Mr. Deepak Mishra. So Honorable Deepak Mishra, he led this situation that people should be given the chance. And the medical board, one you know, fellow friend was saying that it is only consisted of 3 doctors. So what exactly these type of people want? That the entire hospital, or you know, 50 or 100 doctors will come and decide. So this is a question of faith. If we have faith in the system, and the person there is no U-turn, there is no return. Just a minute. There is the entire arrangement is there that this particular person cannot come back. So that is the real thing. If the violation of that clause is there, then the people who are guilty, they will be punished.
Yes, there is a system in place.
The provisions are always there in the IPC also. So we should.
How do you even find out?
Huh?
How do you even find out, sir?
Involving the magistrate.
I think it's such an
involving the
impractical
magistrate.
thing. I mean, if you have worked in a hospital,
so that medical board,
you will understand.
See, no, medical board. See,
most of the time,
what will happen?
Know.
What is
none of this,
you
even
yourself,
if this is grossly misused, it's hardly ever going to come out, because the family very often is colluding in this. The doctors and the family collude.
My dear
so
brother,
who will go and give a complaint?
dear brother, see,
I mean,
misuse of the system is everywhere.
Of this, nobody will even know about
the system
it.
is everywhere.
All right, let me bring in Pinky Virani, the one who argued for this, or the one who approached the Supreme Court.
Gentlemen,
what have you achieved?
Shouting in the channel.
All right. Let's calm down. I want to bring in Pinky Virani. Pinky Virani.
Shouting in the channel is
so it's all boiled down to this. Gentlemen, one second, please.
Thank you for giving me a chance to speak.
Yes, Pinky. So this, it just everybody seems to be asking the same question.
First, point out. I just want. That is misuse, right? Misuse.
Yes.
And conflating organ donation with it.
Yes.
That was pretty funny as a point, actually.
No, go ahead. What's your rebut?
Look, let's have clarity that we are talking about passive euthanasia and not active. Let's have clarity that what began as a landmark judgment in 2011 has been revalidated as a landmark judgment today. This is about the right to die with dignity. This also means I have a right to say I can donate my organs irrespective of how I'm dying or when I'm dying. So to conflate the two is to in fact create confusion in a very, as it is a very low number of organ donors. And if there are loopholes to be plugged there, which indeed there are, and as the doctors themselves point out, it's because of their own profession, then that needs to be done. But you have no right to even assume that you can take away one right of mine because the Honorable Court has given me another right. I mean, that's ridiculous. So everybody calm down. Please go read the judgment. It's giant. You'll find many of your stuff registered and addressed there. For whatever is not addressed, alas, we are now in election year. The Health Ministry, the Union Health Ministry, has been working on a draft, which I have to say is a very, very kacha draft. Some of us have contributed to it.
Yes.
Some of us are looking forward to seeing it being made much better. And in time it will. We are here as private citizens. They are here as doctors. All those who have a problem, we will make sure that it's all plugged, the loopholes. But to expect it this year, election year, maybe we should just let them get on.
Let me just bring in some people on the phone line. Anil Saraf, right. Anil Saraf is on the phone line. He has a question for us. Anil Saraf, go ahead.
Yeah, Faye, thanks for a lively conversation. I just want to ask the panelists that whether, I mean, the cancer patient in the last stage, I have seen two family deaths dying inch by inch. So can the cancer patients also go for euthanasia?
Can the cancer patients? So I just want to make it clear that this is not euthanasia. This is actually passive euthanasia, which is withdrawal of care. Geeta Luthra, I'm going to go to Geeta Luthra with this question. Cancer patients, or perhaps someone who's specifically terminally ill, but that not all cancer patients are terminally ill. Geeta Luthra.
So I think that if we carry it to a point where a cancer patient who is not terminally ill, who is not in a vegetative state, then we are really talking of an active euthanasia. I think that Supreme Court has not permitted. And perhaps in time, active euthanasia will come, where you can inject a person. But at the moment, it's not permissible. And I think it's really to take baby steps to ensure that there is the misuse or the possibility of misuse is actually plugged in, and then we can take those steps towards active euthanasia, as there are in many other countries in the West, including the Schengen countries, including Switzerland, Norway, Belgium. But till then, it is not permitted in India.
Dr. Nagar, you had an answer specifically for the cancer question.
Yeah, that's the point I was making, that persistent vegetative state is a very specific state, but terminal illness is a very broad entity, and that's, I think, the area which will need good, careful definition, and Pinky Virani promises us, and I'm sure there will be a lot of work on this. But you know, I just also want to say, constantly there is a reference to Schengen countries, Netherlands, but the fact of the matter is that what we seem to be doing, and I'm sort of find it difficult to put it this way, but what we are probably doing is we're talking of right to die with dignity, perhaps without ensuring right to good health care with dignity. Right. And that's a problem, because if people are going to spend large amounts of money, and that's going to be a confounding factor. If we don't have a right to life with dignity in healthcare, with good healthcare, exactly. This is a jump, and that's what is going to create a bit of a problem.
So it's important to take a look at the quality of our healthcare as well.
One point to
make. Yes, Sumanthi Raman. Yes, Suman.
One quick point, Faye. Faye, one quick point. Yeah. No, I just want to request all the panelists on the show to spend 1 week in a critical care unit watching people die, and then they would have a completely different perspective of this whole thing. Classic example, terminally ill patient. Somebody has got an advanced metastatic malignancy with extensive spread, stage 4. Now he comes with an acute event. Now he is terminally ill, but if you do manage to treat him and save him from that acute event, he could still have 5 to 6 months of reasonable quality of life. Now how do you take a call on that? I mean, each patient is different. There are very few clear-cut cases where the family, the doctors, everybody can be in unanimous opinion on pulling the plug. So it's not easy, and my only appeal is, you know, for the lawyers who are talking from the court perspective, please come, spend a week observing what happens in an ICU, and then form a judgment on this
absolutely.
whole
I just want to add to what Sumant is saying, and the other question, and while you know, is developments in medical science and treatments. Now, you might consider something, you know, non-treatable or, you know, beyond the scope at this point, but medical science is developing at a very quick rate. What if a treatment is developed or a treatment is identified in the months to come or in the years to come? Go ahead, Amitabh Sinha.
Absolutely.
Only one very quick intervention. See, Mr. Sumant or other panelists, they are trying to say that this decision will actually attract untimely death to people who are terminally ill. I am sorry, this is a pessimist way to look at. See, the main role is the role of doctor. If doctors think, and not only one doctor, the medical board will decide that the passive euthanasia is permissible or not in that particular patient. So everybody is forgetting that. So family members are not the ultimate people who will decide that the passive euthanasia is possible for that particular patient or not. So the doctors in every aspect, they are here to decide that person cannot be brought back. So that is very important thing, and the donation of organs is a completely different aspect, and it should not be attached. Mr. Sumant, I think all points are generally pessimist point,
and sorry,
we must try to do that in the
hang on. Mr. Sinha, every conversation has
got a right to donate. I mean, he's talking completely incorrect stuff. Faye, look, it is not only the patient who can donate the organs. If the patient is incapacitated, the family members can take that decision. I don't think he knows that. Please go ask him to read up the Organ Donation Act.
Okay.
The family members can also have the organs donated if the patient is not in a position to do
so. Is that a risk, Dr. Nagra?
Personally, you are challenging. Okay, you are challenging that we are talking like lawyers only.
For your question. Hang on. Let me get answers for your question. Dr. Nagra, is that a risk?
Yeah. So Suman,
okay, gentlemen, Mr. Sinha, let's calm down
with the medical board and selling the organs.
All right. That's a scary possibility, and we understand that this already happens in our country. Dr. Nagral, what is the risk of that? Viable organs plug being pulled because there's money to be made.
At the cost of repetition, and Suman knows this, that organ donation is possible today by the law in a subset of patients who are brain dead. So that's what we should get clear. We don't take organs from somebody who is in a persistent vegetative state or somebody who is otherwise terminally ill. The point, however, that is being made by the court is that since in the context of brain death and organ donation, we have moved to some sort of living will, they have extrapolated it. Now, Suman, I know that it is possible that the medical system is under pressure sometimes and the family is under pressure, and organ donation unfortunately gets linked to early disconnection of care. But that's not the key issue here. The key issue is a large number of patients who are not brain dead, who are in persistent vegetative state, where there is no question of taking organs. Yes. So I don't think we should conflate it too much.
Okay, we have also Anurag Sharma on the phone line from Vadodara. Anurag Sharma, go ahead.
Yeah, good evening.
Good evening.
I've heard all the panelists, and I think that this is a very welcome step by the court. And yes, there are many loopholes in this. There are laws for rape, extortion, and whatnot. But then people are indulging in it. And as for this euthanasia, I mean, people will go for it because they cannot afford medical bills. If I would have to go for it, yes, I will see what my family is going through. And there has to be a three-tier people. Let's say psychiatrists are there, judges are there, a medical council is there. They will decide whether the person is in a vegetative state and can be given death of dignity.
Yes, no, but I think you've misunderstood here, Mr. Sharma, that the decision or the living will has to be made when you are okay, when you're normal, like how any will is done. Because when you reach that point, you won't be in a position to make the decision. So at what point would the psychiatrist's assessment be looked at? When you make the will or when the will is being executed? Let me go over to Pinky Virani back again. Pinky, questions about organ donation you addressed. What about, improvements or developments in treatment, things like that? Other questions that are popping up at this point. I'll give you that last word, Pinky. Go ahead.
I think all questions are valid, and I think that the most important thing that is happening with the 2011 judgment and now with the revalidation today is that thanks to the Supreme Court and of course thanks to Aruna Shanbag, because all of this, passive euthanasia, living will, so many other things have also come in other laws like in the anti-rape law, etc., which we've managed to put in, are all because of Aruna Shanbag, the woman who received no justice whatsoever. So we have to be very clear on that. Now, questions will come in. There are no two cases which are alike until such time as the Supreme Court has done its job magnificently of increasing legal literacy. So we can all start conversations with our own families in terms of what can be, what should not be, because again it will be based on what religions we follow, what cultures we follow, what kind of, let's say, moral compass we have. I don't like the word moral really, because morality and when death sets in, the two don't have anything to do per se with each other. But every family follows its own, so to speak, moral compass. And if you feel that you want to make a living will later, start talking to your family, start talking to your doctor. Don't be in any hurry to make the will. Just start the conversation among those whom you love, among those who care for you, and then see how it goes in your own life. The choice ultimately is yours. The Supreme Court has given this massive judgment as a choice. The living will is also a choice. Exercise it if you want, and whenever you do, exercise it wisely.
All right, very well said. I have to wrap up this discussion here, but like Pinky pointed out and like our other panelists pointed out, this is a step in the right direction to give us all a right that we didn't have previously. Yes, there's work to be done within the medical community and among all of us for the literacy to understand what this really means, when it can and cannot be used, and what our rights are. But that doesn't mean we don't have to take the step at all. Let's also take a moment here to remember Aruna Shanbag. We're going to go back to that early photograph of hers before this incident occurred, before this crime was committed, when Aruna was just a young nurse in her 20s who was looking forward to her entire life. She was about to get married and she had a career that was just taking off. It's a reminder of horrible human brutality that left Aruna in this. That's Aruna. That was what she looked like before the incident occurred. It left her in this state for over 40 years. But it's also a reminder of human kindness, where generations of nurses at the KEM hospital selflessly looked after her and then fought in Supreme Court that she be allowed to live, in a case that said, let Aruna Shanbag die. Aruna Shanbag finally died at the age of 66. And today, as a result, we all as Indian citizens have been given the right to a living will, where we can decide today, in your current state of mind and in possession of all your mental faculties, that if you were at a point of no return, that your family members should let you go and not take any drastic steps or use any artificial measures to keep you alive. Thanks for watching.